Okay, well, good morning, everybody. Thank you for joining us this morning, and thank you for the opportunity to talk with you a little bit about investigations, specifically internal investigations in your agency. And so I certainly want to welcome everybody. I appreciate you being here, taking the time out of your morning, because whether you are an EMS administrator, a fire chief, or the director of a 911 center, of course, handling employee complaints and doing investigations is probably one of the most stressful and most important parts of your job in administration. So the decisions that we make in those moments right away and in the follow-up investigation can really have a significant impact in the eventual outcome because it can expose us to some liability. And so we want to talk a little bit today about how we can maybe make a process that is as sound as it can be, just some of the things we want to watch for, make sure that we look at as we go through kind of that investigation process. And so we're going to talk about a case from Honolulu where I'm not picking it all on the folks in Honolulu, but essentially everything that could have gone wrong, I think, went wrong in that case. And so it gives us a good place to, I think, look and identify some of those areas that we need to focus on as we're going through, so that hopefully by the end of the webinar, you have a pretty good step-by-step framework to kind of ensure that you're following the best practices possible. So I'm going to go ahead and get my screen up here. All right. And so, as I said, this is from complaint to conclusion, conducting legally defensible internal investigations. I'm Frank Flaspohler with EMS Legal Services, and I provide just kind of serve as general outside legal counsel for quite a few ambulance districts around the state. I'm very fortunate to be able to do that. I took over for Mr. Frank Foster after he passed away in 2003. And so very grateful for the opportunity to follow in his footsteps. I do want to give a special thanks this morning to the Missouri Ambulance Association because they were grateful enough to help us offer some continuing education through this program. And so just as a reminder, this webinar is eligible for continuing education, both for EMS ground service ambulance administrators and for ambulance district board members. So you guys know that if you're in either of those roles, you have to get continuing education now. And so this gives us the opportunity to provide that to you for free. There will be a recording of this that we'll post on Prodigy. Prodigy EMS is the interface that we're using that you can go and others can watch this later. But I think there's a nominal charge for that because, Prodigy has some administrative costs. So you get it for free today. So if you complete the survey at the end of the program, you have to answer a few questions and then make sure you give me your name and email, and we will get certificates sent out to you for everybody who attended live. I also want to point out that this year is actually the 30th year for the Missouri Ambulance Association. Started in 1996, July 24th, 1996 is actually when it was filed with the Missouri Secretary of State. And so for the past 30 years, they have served as one of the statewide associations for EMS. Their original purpose outlined in that filing back in 1996 was to promote friendship and cooperation among persons engaged in the provision of ambulance service and related emergency medical services. So for those of you who are 911 telecommunicators or fire personnel, certainly you are welcome to join us at the summer seminar because you are just like those of us that work on the ambulance. We are all engaged in providing emergency medical services, whether that's as a first responder or as a telecommunicator providing emergency medical dispatch. We're all part of that same team. And so we would welcome you to that summer seminar. It's going to be a great thing. They're going to have a band, and they have their annual Frank Foster networking dinner. So please, if you have the opportunity to come down to the lake, join us for those couple days. I do want to give a shout out to the original board members for the Missouri Ambulance Association, just to recognize those folks. And you may recognize some of these names. So the very top of the list was, of course, Barb Shoup, and she continues today to be our executive director for the Missouri Ambulance Association, but she was one of the original board members back in 1996. We also have Vicki Gross, Sharon Robinson, Joseph Russell, Robert McGee, Ralph Hellebush, Sherry Calvin, and Patrick Kelly. So those were the folks that helped us get started 30 years ago. So we certainly appreciate their service. I want to give you just a little bit of a roadmap of what we're going to look through today in today's webinar, just so you know what to expect. We're going to start, I mentioned this case from Honolulu, Hawaii, which is kind of maybe a little bit of a cautionary tale for investigations in EMS. But it's going to kind of be the backbone of our discussion today. We're going to keep looking back at that and referencing it. We're not doing that at all to point fingers, but just because pretty much every mistake that was made in that case is a pretty good lesson of what we could do instead. And so we're going to use that as a springboard throughout this morning. From there, we're going to talk about intake and triage, kind of what we need to do in that first 72 hours after receiving the complaint, how we need to begin our investigation, and then how we can plan our investigation, how we can define the scope, make sure we choose the right investigator. So we've got somebody that is neutral and impartial, so that we can carry out that investigation. And then we want to talk a little bit about just some of the basics of evidence and obtaining evidence and how we might weigh different kinds of evidence, and look a little bit at surveillance, because that's one of the things that comes up in the Honolulu case. We're going to wrap up with some of the employee rights from these three Supreme Court cases, Loudermill, Garrity, and Weingarten, that are all pretty key cases that tell us when employees have certain rights that we need to respect. And then we're going to wrap up talking about that decision, that final conclusion that we make sure we're documenting that in a good and concise report that will provide essentially our defense in the event that our decision is contested at some point in the future. So let's just start by talking about this case in Honolulu. I want to give you a little bit of that context. It comes to us from May 2023, and I think illustrates how bad things can get when the process is not handled well. And so Honolulu EMS actually works with a union. So there is a union involved in this case, which is important, especially for those of us that work with unions, but important to understand that context. The city received an anonymous tip claiming that two of the paramedics were using their supervisor vehicles to go home and sleep while they were on duty. But instead of calling the paramedics in and asking them about it, the city decided to spend about 2 months doing a secret investigation with a private PI firm that notably the firm was the firm owner, although a respected PI firm, was a pretty good friend of one of the administrators at Honolulu EMS. And so kind of got a buddy to do the investigation. And then ultimately after that investigation, although repeatedly denying to the union that there was any investigation going on, the city ended up firing both paramedics in 2024. Of course, as I said, there was a union was involved, and so the case ends up before arbitration. And for those of you who are unfamiliar with arbitration, arbitration is essentially like a private court proceeding. So it's a little bit less formal than the courtroom, but in the end, it's not like mediation where both sides get to agree to a conclusion. Arbitration is essentially you each present your case and your evidence to the arbiter, and the arbiter makes a final decision that is binding upon everyone. In this case, the arbiter's decision was pretty scathing for Honolulu EMS. It reinstated the paramedics and referred to the city's investigation basically as mere legal camouflage. The arbiter found that the city fired the workers for violating a rule that did not even exist, because there was, in fact, no policy in place that restricted individuals from going home while they were on the clock. There was also possibly some FMLA consequences. The arbiter didn't talk about that in great detail, but one of the medics claimed that they were going home to take care of a sick family member, and so possibly some other issues there. But in the end, this kind of botched investigation cost the taxpayers in Honolulu over $300,000 in back pay and attorney's fees and some pretty significant damages there. So some definite negative consequences for the agency. So why, of course, that matters in the state of Missouri? Well, the reality is that many of the legal principles that were applied in the Honolulu case would also apply to us here in Missouri. So many public sector, EMS, fire, 911 telecommunicators, although the default in the state of Missouri is that we are at-will employees, the fact is that there are quite a few occasions where that at-will employment might be converted to individuals that have what the court refers to in the Loudermill case as a property right in maintaining their job. And so as public sector employees, we want to be very careful of simply relying on the idea that they're at-will employees. If we have a union in place with a collective bargaining agreement, but also we can have certain contracts with our employees. All of these things kind of move our employees out of that at-will employment. And so we just want to be very careful dealing with our employees as if we could fire them for just any reason. Because many of our employees we'd see would have what we're going to call just cause protection, which means we can't take away their job without a proven, valid, and fair reason, and some due process as part of that. That due process really comes to us from the Loudermill case, because Loudermill defines that those due process rights, outlining that a government employer can't take away a public employee's job without giving them formal notice of the charges against them. So really that notice, being informed about what it is we believe they did wrong, and giving them a meaningful opportunity to explain their side of the story. And so we always need to keep that in mind anytime we are determining, but again, that should happen before we make the determination to discipline or terminate somebody. But we want to let them know what they're accused of and then give them an opportunity to tell their side of the story. Doesn't mean we're going to believe their side of the story, but we need to listen to it and certainly consider it. Because if we skip those steps, then really we're at risk for conducting a biased investigation. And that biased investigation, like the one in Honolulu, is one that can result in some pretty negative outcomes for the district, right? So reinstatement, back pay, attorney's fees, all those expenses can be triggered if we don't do a good job following through with that investigation. So when we receive a complaint or any information that leads us to believe that there may have been something that was done wrong, that first 72 hours is really pretty crucial in determining and really laying out how our disciplinary process is going to be reviewed later. And so we want to be really careful that we're following a consistent approach in doing these investigations. So our first step, of course, should always be to document the complaint in writing. So sometimes we may get a complaint from a patient's family. Sometimes we may get a complaint from a coworker. Obviously, if it's a coworker, then hopefully we can get the employee to document that in writing. But even if it's just a complaint that's given to us and maybe the family member says, hey, I don't want to do anything about this, we need to document that and investigate it. Just like, by the way, if we had somebody come and say, so-and-so on the shift is telling jokes that have a sexual connotation to them, but I don't want to get him in trouble, so I'm not going to write anything down. Obviously, unfortunately, you do not get to, no employee gets to come to their administrator and say, hey, I'm going to tell you this, but I don't want you to do anything about it, right? Our role as administrators mandates that when we get that information, we have to do something about it. And so certainly we want people to confide in us, but also our employees have to understand that when you make a report to a supervisor or an administrator, we can't just ignore that, even if you want us to. So that certainly we're going to document all of those verbal things, even if maybe it's made anonymously, right? So we always want to document that. We're going to classify the nature of the complaint. So are we dealing with something that maybe is sexual harassment or racial discrimination, or suspected criminal conduct? Are we dealing with something that is a clear safety violation, or maybe just a routine violation of policy? We need to make sure we've categorized that correctly so that then we know what steps to follow through, right? Because we may deal with those different things a little bit differently, right? And also the employee's rights may be a little bit different, especially if we're talking about criminal conduct, right? So we want to make sure we've classified what the scope of the issue is so that we can move forward with our investigation. Then we want to certainly assess whether the subject of the complaint needs to be placed on administrative leave, whether they need to be on paid leave or unpaid leave. Of course, if you have a collective bargaining agreement, we're going to look to that to determine what kind of leave that they're placed on. But certainly, if we've got somebody that is a safety risk, that has made poor decisions in a safety related situation, then we don't necessarily want them continuing in service until we have addressed that. And so many times that means we're going to put them on paid administrative leave
Nope.
while we review the situation. Um, Before we
So
start
I'm
interviewing,
listening to a meeting.
but okay, but before we start interviewing people, before we begin our investigation, though, please remember that we need to identify the specific rule or policy that the employee is accused of violating. And so that's one of the things I think that did not happen. One of the keys that we should take away from that Honolulu case is they identified certainly what is a potential issue, right? We don't want supervisors going home and sleeping on duty. But at the same time, if we don't have a policy for that, then we need to recognize that right away. And so, certainly in the very beginning, we need to be identifying that specific rule that is at issue. And then finally, during that 72 hours, we're going to decide who is going to take ownership of the investigation. And so, who is going to be responsible for conducting the interviews, looking into anything, and we're going to make sure that that person doesn't have any potential conflicts of interest. We're going to make sure, for instance, that we probably are not having somebody's direct supervisor investigate them. We want maybe somebody outside of their normal chain of command so that we don't have any sort of bias from somebody who regularly works on the shift with this person. Likewise, I have seen from time to time where yeah, certain districts or agencies will want to appoint a board member to do an investigation. Let me just say that I think that is a horrible confusion of the role of a board member. Even if maybe suppose the claim is against your administrator, well, we need to find somebody who's outside of the decision-making process that conduct that investigation. We should never have an individual board member doing an investigation on their own. Of course, as you know, if you took the board training, all board members act together with the rest of the board. They do not act individually. And if we've got a board member out there, I don't want to say going rogue, but it's as close to going rogue as it could possibly be, out there doing their own investigation, even with the approval or blessing of the board, we've just horribly confused their role as a board member. So please don't have your board members doing investigations. So let's talk a little bit more about who runs this investigation, because picking the wrong person can definitely somewhat poison the entire process, right? Like we saw in the Honolulu case, you pick somebody who's the friend of the administrator. Well, that's going to come out eventually if it's contested. And then it muddies the whole process. So the golden rule really is that the investigator should never be someone who has a personal stake in the outcome of the case. It should not be a personal friend of the administrator or of the supervisor. Certainly not of the person making the complaint or of the person being investigated. And I realize some of us are from small agencies, and that can be very difficult. If there's only 15 employees, right, then it's hard to find somebody who isn't friends with somebody else. It may be an opportunity to talk to somebody outside of our agency about doing the investigation. Because again, we do want to avoid using somebody in that direct chain of command whenever possible, because it just creates this perception of bias. Well, my supervisor doesn't like me anyway because they've been upset with me for the last 6 months because I'm not doing what they want. Really want a neutral investigator who can conduct the process. As I mentioned, in the Honolulu case, the city hired an outside security firm, but the city official that directed the probe was really personal friends with the investigator. So much so that even though they had an outside firm allegedly conducting the investigation, the city official was feeding them questions, telling them what to look into, telling them how to conduct their investigation. And I think that really just completely destroyed any idea of neutrality in the case. So for routine complaints, certainly a trained internal staff member, like a deputy chief who wasn't involved in the incident, is certainly fine. But if the complaint involves somebody in leadership, especially somebody in senior leadership, I would strongly encourage you to look at getting an outside investigator. There are attorneys who can certainly assist with that, former law enforcement partners, retired investigators who can help us with that. But somebody who's really neutral that can do that investigation from outside the agency, especially if it involves a complaint involving somebody in your senior leadership. We always want to document any prior relationship the agency has with an outside investigator. So if the individual is a former board member, well, that might be okay, depending on the level of involvement they had with the individual that they are investigating. But certainly, if it's a former law enforcement partner, we just want to document any possible conflicts of interest and recognize that. So I mentioned one of the keys in the Honolulu case is really this idea that we have to have a rule in order to punish somebody. There's no punishment without law. If Frank Foster was here, there's a really awesome Latin saying that basically says the same thing: no punishment without law. I can't say it in Latin, so I will forego that. But basically, you cannot punish an employee for breaking a rule that does not exist, right? And that's probably the biggest issue in the Honolulu case. Employees, of course, have the right to notice. They have the right to be informed when their conduct is inappropriate. But they can't possibly know that the conduct is inappropriate if we have not told them that, right? So if we don't have a policy that defines the conduct as unauthorized or inappropriate, then it really goes against their notice about the inappropriate conduct. We shouldn't rely on sometimes there are vague handbook phrases like conduct that interferes with duties or conduct that is prejudicial to their position. We want to be really careful relying on those kind of vague handbook phrases, right? And so if we are having to search and really dig and use all of our creative juices to come up with a policy that is being violated, that probably is a good indication that there is no specific policy that's being violated. In the Honolulu case, for instance, the city investigated and fired the two paramedics for taking their vehicle home while on duty, but there was no policy prohibiting that, right? So, in fact, I think it was kind of concluded that it was a fairly common past practice. And so the arbiter pointed out that it would be really unfair to punish those workers for doing something that everybody else had done and that the agency had never taken the time to put into writing that it was not permitted. Now, the city didn't help themselves, right? Because they immediately issued a brand new policy that ban the practice just one day before the arbiter forced them to reinstate the paramedics. That doesn't really look very favorable. So let's not find behavior that we don't like and then immediately issue a policy prohibiting it and then do an investigation under the new policy. That's not going to work. That's going to lead to liability for sure. So if you discover that one of your employees is doing something that's problematic and you realize that you don't have a policy against it, um, then probably a disciplinary investigation is not the way to go. And you should remember that because I think it's one of the, in fact, I know it's one of the questions in your quiz at the end. So if you discover that you don't have a specific rule prohibiting the policy, you don't do a disciplinary investigation. That is an opportunity for a conversation about developing the policy and improving things for going forward. It's no longer about disciplining that employee. So please remember that so you get the right answer at the quiz, right? So as part of our investigation, we're going to put together an investigation plan because we always want to be deliberate in the way that we are going through this process. And so we really want to come up with a plan. We don't want to fly by the seat of our pants because that's essentially how we're going to make mistakes, right? So we're going to have a plan for our investigation. We're going to start by defining the scope of the investigation. So specifically, what are the allegations? And as I said, what policies are allegedly involved. So we've got that right from the beginning. We know what policies we're looking at. So we know what facts are relevant and important to those policies. We're also going to determine what time frame we're looking at. So we're not going back 6, 12, 36 months, right? We've identified the time frame, we've identified the policy, and we've identified what the allegations are. That really is the scope of our investigation. From there, then, we can determine what evidence we need to collect. And so that can certainly include documents like patient care reports, dispatch audio, GPS data, our computer-aided dispatch records, all of those things would be good evidence in reviewing. Security cam footage, maybe camera footage from body cams. All of those can be very helpful to us. We're also going to create a list of witnesses that we want to interview. And so that list of witnesses should include everybody who was involved in the incident. So if we have an employee complaint and they say, hey, there were 3 other crew members there, well, we're going to interview all 3 crew members, right? We're not going to interview just the first one and go, oh, we've got the evidence we need. We've got the statement. Now we can go forward. We're going to interview all of the witnesses that would have firsthand knowledge of the events. Not just the ones that are easy to talk to or the ones that are willing to talk to us. We're gonna talk to everybody. We do want to establish a timeline so that we've got some so we keep things moving in our investigation process. Again, sometimes we see liability arise in cases where the case kind of stalls and it goes on and on. But we want to keep that investigation moving forward. We need to make sure that we account for giving notice to our employees, deciding exactly when and how the subject of the investigation is going to be informed about what's going on. Please remember to check if you are part of a union shop, check that collective bargaining agreement. Go back. You should be very familiar with that as an administrator, especially in that disciplinary process, because we have some very strict legal obligations that we often have to follow, including involving the shop steward or union leadership. And so we don't want to be pulling people into interviews or closed meetings without involving the union. Because one of the biggest ways to upset the union is by ignoring the process that we have agreed to in that collective bargaining agreement. So please be very familiar with that. So when we are gathering facts during our investigation, we certainly want to understand there's a little bit of a hierarchy of evidence, right? Because not all proof is of equal value, either to you or to the judge or to the arbiter. We understand there's a different levels of reliability or credibility that are given to certain records. And so there are things like DNA evidence, fingerprints, or other forensic evidence. often this would include things like body camera footage or surveillance footage, that these are really highly reliable pieces of evidence, right? Because they can be verified by third parties. And so definitely we want to keep those in mind. If we've got those, they can be very conclusive evidence. But there are also things like computer-aided dispatch logs, so your CAD records, your patient care reports, your EPCRs, payroll records, witness statements, all of those things that are generated in the course of business that can be reliable evidence. But we remember that they are documents that are created by people. And so there certainly could be errors in there. Likewise, witness statements, of course, from firsthand witnesses that observe the statements. We want to make sure we've gotten those in writing. We've documented they're dated, signed, and preserved. But witness statements, of course, are somewhat subjective as well, because again, depending on how long we're thinking back, our memories can change, or we can remember things a little bit differently. And so we certainly want to be cognizant of those witness statements. They can also be biased, right? So we need to keep that in mind as well. We might have direct observations by our investigator. So if the investigator is doing some investigation and they find something that they come across, certainly we want them to document those observations as well. I think probably at the bottom of our hierarchy, we're going to have things like anonymous tips, third-party reports, which in law we often refer to as hearsay, right? These things here at the bottom, they really need to be verified by careful investigation so that we can support their credibility. That's not to say that an anonymous tip doesn't have value or that a third-party report with hearsay doesn't have value, but we're going to want to document that with some other credible evidence, right? So we're not necessarily just going to rely upon those things by themselves. Just as a warning to EMS, 911, and fire personnel, because we really like GPS sometimes, right? But there can be a temptation to treat some of that as some of these technologies as flawless. And we want to remember that they're not always flawless, right? So our law enforcement partners might have like a portable breathalyzer machine. And the courts have repeatedly told us that a portable breathalyzer is not scientifically proven. You have to actually use a real breathalyzer machine. And so likewise, for some of those GPS and tracking features, unless it can be verified by third party, then oftentimes those systems are just not currently technologically reliable, right? So I know my brother was just talking to my niece who's 16, and they use that Life 360 thing, and he said, well, I saw you were going 111 miles an hour in your car. And by the way, my niece has a car that could not possibly go 111 miles an hour. I don't care if who was driving it. So, but sometimes GPS gets those things wrong. We've seen that in our own GPS, I'm sure. So just remember that if you're relying on those technology things like vehicle tracking to discipline an employee, make sure we're validating that by an independent source to really ensure that it's accurate. Regarding surveillance and individual and employee privacy, I just want to caution you about using covert surveillance on any employees. And so we saw that in the Honolulu case. Rather than talking to the employees about what was going on, they hired this private investigation firm to essentially stake out at their house and see what the employees were doing. Conducting secret surveillance, especially on an employee's home, is going to raise some pretty significant legal and privacy concerns. And so, especially in Missouri, we have a tort, which is civil liability, but called invasion of privacy. And so certainly that would be some potential liability for us. But beyond that, if our employees are part of a collective bargaining agreement, unilaterally spying on them might be considered subject to that agreement. Meaning that you wouldn't be able to do it without talking to the union first, right? So that was one of the things that happened in the Honolulu case. The city official shared the home addresses with this security investigation firm without the employees' consent so they could stake out their houses. And the arbiter certainly did not appreciate that fact. And so we just want to be really careful anytime we're using covert surveillance. Now, if there are cameras in the station, cameras in our vehicles, obviously everybody knows about that. That's not covert, so we can use those things. But secretly investigating our employees is um, certainly cause for concern, and I would be very, very cautious about doing that. We don't want to hide outside the bushes of our employees' homes and try and track what they're doing. As part of our investigation process, of course, we are going to do an interview. As I said, we want to interview everybody who was involved in the process or everybody who might have observed what happened. Conducting that interview in a fair way is somewhat of an art form, right? So the general principle in doing those interviews is we usually work from the outside in. So we don't typically bring in the subject of the investigation and interview them first. Maybe we interview the people who were bystanders, and then we interview people who were involved in the incident. And then we're going to talk to the individual subject of the investigation last, so that we have the fullest possible picture of what happened before we sit down with them. But we don't want to surprise people in our interviews. We should schedule those interviews in advance. Let them know the general subject matter that we're going to be discussing. Of course, we can ask them not to talk about that with other employees. And we want to conduct those interviews in a private setting, certainly where the employee feels secure. Or if we're bringing in a patient's family or a member of the public, we want to do that in a private area where, again, they feel comfortable talking about what happened. Where the state law allows it. And so in Missouri, certainly we can record those interviews if we'd like. That can be certainly advisable, so that we've got that on record, right? So we have a documentation, an audio recording of what happened in the interview. We may also provide the interview or the individual being interviewed with the opportunity to provide a written statement or correct any misunderstandings. We want to ask them questions, get all of the information and document that, right? So the interview with the accused employee is especially important. In fact, the explanation of the interview is perhaps the most important aspect of your investigation, right? And so we definitely want to tell the employee what it is we found, tell the employee what we found in our investigation, and then ask them for their side of the story. Ask them for their explanation. Ask for them to, and make sure you give them the opportunity to let them tell you in your words what happened. Now, maybe they admit to it, right? And that's wonderful. That helps us. Maybe they provide an entirely different explanation, and then we're going to have to look into that a little bit further. But we always want to provide that employee the opportunity to tell their side of their story. So I do want to look at these kind of major rights that we want to that come to us from these Supreme Court cases that we want to appreciate and respect during the interview process. First, there's this Loudermill case, which, as I mentioned before, applies to public employees with a property interest in their job, and that's going to be many of our employees in fire, EMS, and 911, right? So before we terminate them, we're going to want to provide them with notice of what they're being accused of, with an explanation of that evidence, and an opportunity to explain or, again, provide their side of the story before we make that final decision. So we may know in our mind that we are likely moving toward termination, but we want to, before we make that final decision, tell them what they're accused of, tell them what the evidence is, and give them the opportunity to provide their own evidence and their own testimony. That is the core of due process under our American constitutional system, right? Notice and the opportunity to be heard are the two very vital aspects of all due process. And that's just kind of outlined for us in the employment context in Loudermill. In our Garrity case, we're looking at cases where there are maybe compelled statements. And so if we are investigating something that could also be a criminal offense, like stealing narcotics or assaulting a patient, um, then we really need to let them know before we're forcing them to provide a statement to us as an employer that that statement could be used later in a criminal proceeding against them. And so, if there are possible criminal consequences to their action, and unfortunately in EMS and fire and 911 telecommunications, we see that increasingly, the possibility of criminal prosecution. Then we need to be very careful if we are compelling them to make a statement because they still have their Fifth Amendment right under the United States Constitution, that right to remain silent. And so we just need to be very cautious when there are possible criminal consequences to their actions. And then finally, we have the Weingarten case that really looks at the union representation. If we're involved with a union shop, if we have a union at our agency, then certainly the employee has the right to request the interview participate or the union participate in that interview process. And we cannot punish the employee simply for asking for their union representation. So again, be mindful of your collective bargaining agreement. Make sure we're following that carefully as you're going through your administrative process. All right, so we do have another Supreme Court case called Enterprise Wire, and this court case gives us kind of the 7 different tests for just cause. And I have a handout, by the way, that I will be emailing everybody with their certificates at the end, and so it kind of outlines these 7 tests for just cause. But we always want to make sure that we're going through this list, right? Because before we're imposing any discipline, we should be able to answer yes to all of these questions. And so that first one is really just notice. Did the employee clearly know the rule and the consequences of breaking it? Well, hopefully they did, right? And so we hope the answer is yes, that they knew what the rule was. Second, is that rule actually related to the safe and efficient operation of our agency, right? And again, hopefully if we're writing policies, we've justified that in the policy, outline why that policy is important, but we want to make sure our rules are reasonable. Did our management conduct an investigation to actually determine the facts before we impose discipline? So is there a record of our investigation before we get to, okay, we're going to just go ahead and terminate this person? And then finally not finally, number 4, was that investigation fair and objective, right? Was it free of those conflict of interest that we talked about? Was there proof of the alleged violation? Is there substantial evidence supporting our conclusion that the employee actually violated one of our rules? And so we're going to review that carefully, right, and make sure we've got that documentation, that proof. Doesn't mean that there's not contradictory evidence, right? Maybe the employee statement is something completely different, but we're going to be able to support our conclusion of why we believed one over the other. We want to make sure that the rule has been consistently applied evenly and fairly. That really protects us from discrimination claims. We want to make sure we're applying this rule equally to everyone. And then finally, is the penalty that we're imposing, is it proportionate to the offense? We're not terminating somebody for a very minor infraction. And so kind of the 7 tests for just cause that we want to make sure, just kind of going over in our mind at the end of the investigation, that we have hit upon all 7 of these points and that we can answer yes to each of those. At the conclusion of our investigation, of course, we're going to provide a final report, and we're going to document our disciplinary conclusion. That may be in a discipline letter, but even if we're giving a verbal warning, right, we're still documenting that. Certainly, if we're terminating somebody, we're documenting that in a termination notice. This final report really should be a comprehensive document that includes everything from our investigation. So the method, that whole plan that we outlined in the beginning, the summary of all the evidence that we concluded or that we reviewed, of course, policy that was at issue, and our finding of fact and conclusion. So what we concluded. And so again, even if we found evidence that may be contradictory one way or another, we've made findings that say this is what we believe to be true, and this is why we believe this maybe over something else. If the employee or the union submits written responses defending their actions, we're going to certainly acknowledge those in the report. We're not going to just ignore them. We're acknowledging them and then again justifying why we concluded something different. In the Honolulu case, for instance, the union provided some defense memos, and unfortunately, the city officials during the arbitration hearing basically admitted that, yeah, we'd gotten those, but we didn't ever read them or pay attention to them. So don't do that, right? We're obviously reviewing everything, we're considering everything, and then we're making a final decision. We don't want to add a whole bunch of minor things or unrelated complaints from the past just to make it look longer. Certainly, if there is an extensive disciplinary history, we can document that in the termination letter. But we want those things to be somewhat connected. We don't want it to look like we just threw in everything from the kitchen sink, right? So, but if there's a disciplinary history, we are going to reference that in our discipline letter. So I have a couple of just hypotheticals here that we can think about. I know we're coming up on 50 minutes, so I don't want to keep you too long. But just a couple hypotheticals here. So if you receive an anonymous letter alleging two of your senior medics left their post to grab meals, you as the chief and one of the medics have recently been through a grievance dispute. Your deputy chief, who dated one of the medics several years ago, proposes a covert restaurant surveillance using her father's PI firm. Well, we can see certainly what maybe would be wrong with that, right? As chief, if we've recently gone through a grievance dispute with that employee, then we may want to find somebody who's not going to be alleged of bias, right? It's not to say that we can't be involved in the investigation, but it would be better if we can find somebody who's neutral, who's not making the final determination as a result of that investigation. And certainly we probably would not want our deputy chief, who maybe dated one of the folks several years ago, to be involved in that. And we wouldn't want to maybe refer it to her father's PI firm. Kind of, again, what happened in our Honolulu case. We just want to avoid those potential occasions for even the appearance of bias as much as possible. And then our second scenario, we have a 911 supervisor who learns that a senior telecommunicator is using a personal laptop at the console during slow periods, maybe managing a side business. If we don't have a specific rule prohibiting it, but we have several complaints from the local police department about the radio response times. We have such a cheery looking police chief in the picture here, but arrives in the office having heard about the laptop from one of his officers and demands that you terminate the telecommunicator. Well, we want to remember that we have to have a rule in order to take disciplinary action on somebody. And here, we don't have a rule prohibiting the use of that private computer at the dispatch console. You and I and everybody else in telecommunications may know that that seems like an awful idea, but if we don't have a rule prohibiting it, then again, we don't need to move this into termination or a disciplinary discussion. We need to move into a policy development discussion. And so that's really what needs to happen in this situation. So just in wrapping up here, I just kind of want to hit upon the 5 key points that I'd like everybody hopefully to take away from this. So number 1, as I said, if we're looking at discipline, the rule must exist before the action happens, and the employee has to know about it all before their conduct occurs. We cannot discipline somebody for a rule that does not exist, and we cannot discipline somebody retroactively. Number 2, we certainly want to pick a completely neutral investigator who has no personal or business relationships that maybe would compromise the integrity of our investigation. And so we want to avoid any appearance of conflict of interest as much as possible. Number 3, that covert surveillance of our employees should certainly be the last resort. And again, just be really cautious there. Be in touch with your legal counsel before we're engaging in covert surveillance, especially of employees off duty. Because there can be some significant privacy concerns and legal risks in doing so. We want to remember those rights in Loudermill, Garrity, and Weingarten, and how they protect the due process rights that we talked about in Loudermill, right? So that right to notice and the opportunity to be heard, that Garrity protection if there are possible criminal consequences, and then the Weingarten protection, ensuring that we're following that collective bargaining agreement and giving our employees the opportunity to take advantage of their union if we operate in a union shop. And then finally, if our employee is giving us some feedback, if the suspected employee is providing a statement, they're providing testimony, make sure we read and review that. That's the key part of due process, right? Is that opportunity to be heard, which means we actually have to hear them, and we have to consider it. And in our final report, we're going to address why we did or did not believe them. So please don't just take their statements and then do whatever you were going to do beforehand without giving it any serious consideration. Make sure you've addressed that in your final documentation. So that is all I have for today. So I certainly appreciate you guys joining us this morning. If anybody has any questions, I'm happy to do questions and answers. But I definitely appreciate everybody being here and participating in the webinar. As I said, I'll get it. We did record it, so it will be up on Prodigy if somebody missed it, hopefully soon, so you can watch it there, and then they, I think, issue your certificate. At the conclusion of the webinar, there is a survey. Please complete that survey. It has a place for your name and email, and then whether you want credit as a ground service EMS administrator or as a ambulance district board member, or if you don't want credit at all, that's fine too. But make sure you designate that so I can get you the right certificate for your attendance today. So I'm going to stop sharing my screen, and I see somebody did put something in the chat. Nathan says, thank you. Well, thank you for all of your service down in Ozark County, Nathan. I certainly appreciate the opportunity to work with you. So I'm going to stop the recording. That way, if you have a question and you don't want it to be on the recording, it doesn't have to be. So.